and welcome to Roadmap 2023, our election issues and personalities tracking program. I am Ladi Akeredoluale. Thanks for joining us. My guest on today's edition says the citizens must not be too hard on themselves or the institutions managing the electoral process. That's because a lot of positives, according to my guest, came out of the process. Roadmap 2023 talks to Senior Advocate of Nigeria, Mr. Wahab Shittu. Mr. Shittu, thank you for your time. Welcome to the program.
It's my pleasure.
We want to take a look at the 2023 elections. But first, I want to get your general view. Some of those I've spoken to have said it has been an improvement on what we had in 2019 and 2015, and certainly an improvement on what we had in 2007 under Professor Morrissey and former President Obasanjo. And that's so, if we continue along this trajectory, it would continue to get better. But there are others I've also spoken to who have said, no, it's only the problems that have changed nomenclature, but that is each election cycle has produced almost the same bad outcomes. What's your own view of this 2020?
My own view is that in our assessment of the conduct of our elections, we tend to be unnecessarily too hard on ourselves and on the electoral umpire without necessarily taking into account all the circumstances. You will appreciate that this 2023 election, against the background of the problems associated with the polity prior to the elections, a lot of problems, fuel scarcity, naira swap, a lot of agony and disenchantment of the populace that could even lead people who are not otherwise committed to the process to decide that they want to boycott the elections out of hunger, poverty, anger. If we look at that situation, people had no access to all the good things of life that ordinarily they should have had access to. People could not move as much as they ought to. They don't have access to cash as much as they ought to. And all of these things came about suddenly. We didn't have enough information. There were litigations at the Supreme Court whose outcome nobody could predict. And then uncertainty as to whether the old naira notes will circulate alongside with the new notes, or whether the new notes will be the only one in circulation. A lot of uncertainty build up to the election. So if we look at all those circumstances and the fact that in spite of all of this, Nigerians still came out to exercise their franchise, I think we should salute the process. And so all of this still impacted on some of the hiccups that we saw during the election. But we take all of this into consideration. And if we are realistic in our assessment, we will know that the 2023 election is a remarkable improvement, in my view. In spite of the challenges, Nigerians were able to come out to say, oh. And if we look at the build-up to the elections in terms of campaign, never in the history of our country have we had such kind of intensity in terms of campaign by all the major gladiators. Talk of the Labour Party, talk of the NMPPC, talk of the PDP, talk of the APC. All of them went round. The campaign was, heated campaign across, going around, and you were almost uncertain as to what is going to be the likely outcome. You never had that kind of engagement before. I imagine that some of the candidates even went around all the states of the Federation, in spite of the challenges. So we should not be unnecessarily too hard on ourselves, because elections everywhere are not perfect. There's nowhere that you have a perfect election, not even in the US. You had hiccups, even when you talk of the hiccups suffered by the application of the beavers. Even you have a technological breakdown even in the US elections. So you can plan for a successful outcome. And that is in the realm of planning. what actually happens in practical times, some of these things can come up and then you don't predict. Your ability to be able to rise above all these challenges is what determines the growth and the success of a country. So in my view, Nigerians are quite resilient people, very determined people who are willing to make the best of every situation. No matter how. So we need to salute the Nigerian spirit. You need to salute the determination of the empire to make the best of a seemingly frightening situation. And then you also need to salute the commitment of the ruling government to deliver a free, fair, and credible poll. You know, the president alluded to that repeatedly. And you can see clearly, if you want to be very fair to this president, that he never did anything to interfere with the process. There was nothing that this president did to interfere with this process. I'm not a spokesman for the president, but at least in terms of his commitment, what he said, and what he actually did, he never interfered with the process. He never, other than, campaigning for his own political party, which he didn't even do until the later stages of the election. You have to be fair. The administration tried as much as possible to detach itself from the process. And then you can also almost even predict that, maybe even the administration was even against his candidate.
That was what I was going to say.
Yeah.
I was going to ask you, because when you said, the president did
you understand me? Because if the kind of reforms, whatever the CBN did, you have to attribute it to this administration. The policy might be very, very sound. This Naira
swap policy.
Policy, very sound. The intention might be sound, but the implementation was very faulty, and the timing very bad. So one can almost say, and there were a lot of speculations in the marketplace, a lot of conjecture in the market. This policy was targeted at a particular candidate, and most of the opinion was swinging in the direction of even the candidate of the ruling party. So you will see that in spite of all these challenges, what is my verdict? My verdict is that we should not be hard on ourselves. There's no perfect elections anywhere. And that's why we look at even the Electoral Act. And people should watch the language of the Electoral is so clear. An election can only be set aside if such an election is conducted in substantial non-compliance
with the Electoral Act and with the Constitution.
With the Electoral Act and the Constitution. And if this substantial non-compliance affects the results of the election, it's a very heavy body.
Some say too heavy.
Too heavy. You have to demonstrate the fact that not only is there substantial non-compliance with the Act, this has affected the results of the election. And
is that too high a burden, you think? Because, of course, in the aftermath of this election, and I get your point when you said we shouldn't be too hard on the electoral management body or ourselves as people and the country. But there's litigation.
Yes.
The principal parties you mentioned, I think perhaps only NNPP is not in court for the presidential.
Let me say, and I say this publicly, when in the aftermath of an election, you find upsurge of cases in court, it's not a very savory development. It's an unsavory development. It's an unhealthy development.
But what do you put that down to? Why do you think that is our own case?
It's our own case because of several factors. It's not something that you can really pin down to one particular factor. One is our system. Well, no matter how you look at it, is not working the way it ought to work. Our system, if our system is working effectively the way it should work, and transparently the way it should work, there will be less room for grievances. There will be less room for disenchantment. So that is one aspect of it. The second one is attitude. The attitude of our political elite. Many of them are reluctant to accept defeat. They only sing the praises of the electoral empire when they win. And they find all manners of excuses to, disagree with the process. When they lose, they find all manner of excuses to say, oh, the process was flawed, the election was not credible, it was not free, it was not fair, it was not peaceful. You want to say that is the attitude of the average Nigerian politician. You understand me? Inability to accept defeat. Even when such defeat is glaring, they want to contest it. So the other one is attitude. And attitude is everything. The third factor that I can really attribute to this process is that sometimes people analyze situations and events based on their vested interest perspective, as opposed to national interest. People look at, there's hardly any commentator in the public space that does not have one vested interest or the other. And all you need to do is to interrogate what the vested interests are, and then you'll be able to see the partisanship. So only very few elements actually interrogate issues from very objective, non-biased standpoint. So again, I mentioned this earlier, and I think I also mention it again. When you take disputes to the judiciary, electoral disputes to the judiciary for resolution, it's a minus. It's not a plus. It's a minus to the extent that you are asking the judiciary to now replace itself with substitute itself with the the people's way. And it's a Herculean task that you now assign to the judiciary. And when the judiciary is doing that duty, we should appreciate this predicament. Election has been conducted by majority of the people, voters, and then you disagree with the process, and when you go to the election petition tribunal, you have 3 people. If it is the court of appeal, you have 5 people, or 3 people, depending, and then the Supreme Court 5 or 7 people to now determine. These people must be people of extraordinary intelligence, and who could work wonders to be able to, and they are doing it. And rather than applaud them, because we create, that is ordinarily not their duty. But because you are unable to get satisfied with the process, you are dissatisfied with the process, you couldn't accept the outcome of the process for one justifiable reason or the other. I don't want to say. You've taken the dispute to the judiciary, which ordinarily should not be. And the judiciary is doing its best to ensure that they make the best out of a seemingly difficult situation. To that extent, we need to commend the judiciary. We need to invest faith in that process, in the people who are, adjudicating. But so that they can do. We don't need to intimidate them. We don't need to threaten them. You can't take your dispute before the judiciary, for instance, and simultaneously be embarking on street protest. It's a contradiction. You cannot be demonstrating violently on the streets or marching to select areas when your dispute is pending before the court of law. You can also not be making statements that, if you swear in a particular person, that's the end of democracy. Because you understand, because you have passed your dispute for resolution before a court of competent jurisdiction. And the assumption is that these people are men of sterling integrity, people who are able to dispense justice without fear or favor. I think that the presumption should be given in their favor. You allow the process to run its course. And again, let me also make the point. What we are practicing is democracy. And central to the practice of democracy is that those who practice it must be prepared to be Democrats. It's a contradiction if you say You practice democracy and you're undemocratic in your approach. And there are certain fundamentals of the democratic, tradition. Respect for the rule of law. Key. Respect for due process. Respect for fundamental rights. Zero tolerance for corruption. And above all, good governance. These are fundamentals. The most important of all these fundamentals is respect for the rule of law. So I think what is wrong with our approach is that we submit dispute for resolution before the court of law, which is a rule of law approach. There's nothing wrong when somebody feels aggrieved and believes, oh, I want to go to court. In fact, it's something that's recommended. But what is wrong is for you to approach the court and simultaneously be protesting on the street. You are sending very dangerous signals that you don't have confidence in what you have initiated, or you are trying to intimidate the judiciary. They are human beings. They are human beings. They have families.
They live within the society.
They live within the society. I think while it is commendable to appreciate those who approach the court, because they are trying to strengthen our democratic process, they are also trying to strengthen the rule of law. We should condemn in very strong terms if the same people also resort to extrajudicial measures, because that will violate. Now, for instance, part of the respect for the rule of law that I'm talking about is that INEC has the right to conduct our elections. It's statutorily charged with the responsibility of conducting our elections. You understand me? And if they err in the conduct of the elections, the law also provides for a mechanism for redress. And part of the rise of the electoral empire is to announce results and declare a winner, whether rightly or wrongly. And once a winner is declared, in the case of a president, for instance, we have a president-elect. That's the rule of law. Now, if you now challenge the declaration in the court of law, until it is set aside, that president-elect must be recognized in fact and in law. That is the law. That's the rule of law we're talking about.
But there are those who are saying that, all these litigations and all questions surrounding the mandate or otherwise should be resolved before that person takes office. That because we have had instances in the past, not at the presidential level, at state level, where someone has taken on a term of office and is almost 3 years, in some cases 3.5 years into the term of office, like we had in Ekiti and in Osun earlier. That before the courts then determined that actually the wrong person was in the office and another person is now supposed to be there. So what do you think? Should we have a further amendment to the Constitution to stipulate that all such litigations must end before whoever wins is allowed to take office?
I agree absolutely that all electoral disputes should be resolved before a party is sworn in, if that is feasible, if that is practicable. Because you also have to look at the practicability. A lot of, for instance, you have a deluge of election petitions. Labour Party has questioned the presidential election. The PDP is in court. Some other parties are also in court, challenging one election or the other. And for God's sake, these judges are not machines. They are human beings.
There are not that many of them either.
Yes. We have a lot of challenges in our administration of justice system. And these challenges is what we need to focus on. Part of what I will also urge whoever is coming in as the next administration to do is to strengthen the mechanism for our resolution of disputes. The judiciary must be effective and must be efficient. Our law enforcement must be effective and must be efficient. If we take effective care of the police and the judiciary, this country will work. The problem we have in this country mainly is a law and order challenge. If you go outside our source, regrettably, many of our leaders visit these developed economies. The difference between them is not that they are better than us. You find our people going there and making a lot of waves, creating a lot of waves. I think the distinction is that the system works. There's law and order. There are consequences for criminal infractions.
Something which is substantially absent in our...
Yes, and that is what we should address first and foremost. Law and order is key for any administration that wants to make an impact. We need an Attorney General of the Federation that understands the workings of the law, that is effective and efficient. We need a president who has a rule of law, who is rule of law compliant. Our institutions at various levels must work in line with the prescriptions of their mandate.
Should we separate the Minister of Justice from the Attorney General?
Well,
because right now the Attorney General is the Minister of Justice.
You
some
see,
are saying that those two roles.
well, it's not in other climes.
Conflict of interest.
In other climes, I think it borders more on the occupier of the office. In appointing the Attorney General of the Federation, you allow character, competence, and capacity to determine, and knowledge of the law. Somebody who has a track record of excellence in service delivery. Somebody who understands how the law works, both in the local and international, arena. It's a strategic, appointment. Somebody who can look at the president in the face and tell him the truth, not minding whether his office or position will be endangered. Somebody who will steer the country on the path of respect for the rule of law. That is very central. Because our problem in the country is more of law and order dilemma. People, when people are treated equally across board, when there are consequences for criminal or other infractions. For instance, the Adamawa Dibeko, which we may have to comment about, is a very simple matter.
Simple?
A very simple matter.
When you are a lawyer,
simple matter. Simple in the sense that somebody decided to run foul of the law.
So who has run foul of the law here?
The resident electoral commissioner.
But he's quoting sections of the law in saying that the INEC national commissioners that were dispatched from Abuja to the state, under the laws enabling INEC to conduct elections and declare results, those commissioners don't have any such powers, that the Constitution does not delegate to them such powers, and that the INEC headquarters that sent them in the first place was the first breacher of the law, if you permit that phrase, and that what he did was to simply return it to law and order, in the sense that it is his role, along with that of the returning officer, to announce results.
You see, let me demonstrate how simple it is. We all know that this is a democracy defined by the rule of law, primarily. And this is a constitutional democracy, in the sense that whatever actions we take must find support in the context of respect for our Constitution. For instance, if you look at our Constitution, and you look at the Electoral Act, and all the guidelines, you look for section 25, 64, 65 of the Electoral Act, clear. Results can only be announced and a winner returned by the returning officer.
Who is not direct.
He is not direct. Direct, you see, INEC, for instance, has representatives to monitor and supervise the conduct of election in all the states. These are direct. That's not the person who is actually in charge of the conduct of the election. The returning officer has custody of the results from the polling units, from the wards, units, and then even the local government units down to the state level. He has this record, is in a possession, is a custodian of the results, who is statutorily empowered. And his decision, if you look at section 65, is final. Once he makes a proclamation on the declaration of a particular candidate, that is final. Except the only condition when the INEC can review it, if INEC believes under section 65, subsection 1A, B, and C, that the returning officer has acted in gross violation of the law, INEC can review within 7 days. That is also stipulated. So in that section 65, the entirety of the section 65, nowhere is the REC mentioned as a person to announce results. So the person, what he has done is ultra-vires, is illegal. So all you need to do is to take him away and deal with him in accordance with the law.
But that in itself is proving problematic, because according to the law that you're quoting,
yes,
the resident electoral commissioners are appointees of the president.
No.
And that only the president, let me just say what is being reported,
okay.
that they are appointees of the president, and that the law's provision is that their removal can only be done by the president acting on a motion from the Senate of a 2/3 majority.
No, you are talking of removal. If we look at Section 6 of the Electoral Act, it says that the resident electoral commissioner is answerable to the commission. Go and read it. You know, when I come before the public space like this to make pronouncement, I come with the law. Nobody has the law off head. Without, you can make mistakes, but the law is there. The letters of the law are there. You have the Constitution here. I have the Electoral Act here. I'm guided by those provisions. They said the resident electoral commission is answerable to the commission. So the commission can take disciplinary powers, actions against the REC, can be suspended. And the fact that it's a REC does not mean it's above the law. There are only 4 people who have enjoyed immunity under our laws. Only 4 people. And while they are serving in their public offices, the president, the vice president, the governor, the deputy governor. Those are the only 4 people who have immunity. The REC does not have such immunity, so if he commits a crime, if he commits treason, which is what he has done, he should be taken out and prosecuted. That's all.
What the Adamawa situation, and indeed a couple of the situations that we had before, seem to have brought to light is the integrity of the people appointed to superintend affairs in INEC. I remember that there was quite a bit of noise made when particular RECs were appointed, and some people pointed out that these are people with known political affiliation. Some of them even contested elections, before their nomination to be RECs and so on, and that therefore, how can you expect them to fairly and independently superintend over electoral processes when they have displayed political biases before now? But then the other people pointed out that there's nowhere in the law that governs the appointment of RECs or indeed any of the other officials of INEC where it says that they must not be card-carrying members of political parties, they must not display political biases. So, I mean, it may be a technical point, but we are now seeing the results, seemingly, of that lack of rigor, if you want to call it that, in the vetting process of those who get put in this position.
I agree with you that we must emphasize and insist on rigorous screening of those that we appoint into some of these sensitive positions and ensure that the appointees are insulated from partisan considerations. We must ensure that, whether by way of constitutional stipulation or statutory stipulation, that must be done. Because it is important that those in charge of the conduct of our elections are devoid of partisanship. There must be people who are transparent in terms of credibility, integrity, and of the process. People who don't have such stigma. We also need to, appoint people who are patriotic enough to know that national interest must override narrow parochial vested interest into this position. I agree with you. And we can stipulate this. We can also emphasize more due diligence in the appointing process. I agree with you. Because the REC who announce results when collation is yet to be conducted and concluded in about 11 local governments, certainly has a vested interest. You don't need to adduce any evidence to prove that.
And this was a rec.
And this is a rec who's a lawyer.
Apart from that, is a rec who, prior in the original election,
Yes.
before the supplementary,
Yes.
one of the parties had complained
Yes.
that he, in the process of superintending, he had displayed some level of, partiality already. So, I mean, if he wasn't already on his guard or aware that he was under the spotlight, that should have put him on notice.
On notice.
He doesn't seem to have.
Yes, you mentioned a point, a particular point, say that because somebody committed a crime, there is a license for you to also commit another crime. Or somebody has breached the provision of the law, then you too should breach it. That's no defense. That's no defense at all. Because as a rec, part of the instruments you should be guided with in your duties, in his own case, he should be guided by the provisions of the Constitution, by the provisions of the Electoral Act, by the provisions of INEC guidelines on the conduct of the election 2022, and the manual of INEC for the conduct of the election. All these are, and all of this have clear-cut provisions forbidding the rec from announcing results or declaring a winner.
So he has no wiggle room, whichever way.
No. And this is an attempt to just create needless confusion. It's just like the person who march in this aircraft. I don't know. There's a funny personality who appeared in and then raising a lot
all kinds of dust.
Dust. No, that's also
creating a breach of
peace. It just elements should be taken out and then dealt with according to law. We must insist on a rule of law approach. Rule of law approach in dealing with our myriad of problems. Law and order approach. Once law and order is effectively guaranteed under our circumstances, 70 or 80% of our problems will be removed.
Now, when you say that, many people's minds will go to the issue of security.
Yes.
And the fact that ahead of these elections, and you alluded to it when you were talking about the challenges that we faced in the run-up to the elections. Security was one of those challenges. There had been arguments prior to that about, we should devolve security to state and, local levels because that's where they're likely to be more effective. Because the elections were on during that period, it seemed to have passed through with most people not noticing. Of course, not people like you, but most people not noticing. The president signed some constitutional amendments into law, removing, for example, electricity, prisons, the railways from the exclusive list and move them onto the concurrent list, which means that states can now get into those sectors. Then the judicial and legislative bodies at state level were also granted autonomy. I don't know what you make of those. Were those efforts to deepen our own democracy, especially because when you mentioned law and order, community policing was not among the ones that he signed into law. He didn't agree to devolve, security to below federal level.
Well, part of the problems of our country generally, and I think most patriotic Nigerians will agree on this, is that our federalism is practiced in the reverse gear. You see, actually what we are practicing in Nigeria is not federalism. It's a unitary system of government masquerading as federalism. You don't devolve so much powers to the center in a federalist setup. In fact, it's a contradiction. If you look at most of the problems we are facing in this country, is because there's so much powers concentrated at the center, and there's some kind of rat race for the center. For instance, security. Crime everywhere is local. You don't bring somebody from Jigawa to come and police people in Anambra, and vice versa. For instance, one, he doesn't understand the local environment. He may not even understand the language. And they might even be plotting to commit, to kill him.
Right there.
Right, he is present and he doesn't understand the language of expression. I think it makes a lot of sense to decentralize policy and allow states to have control. If you look at the civilizations that we attempt to copy, even in the USA. All these, they have their local police. And then the advantage is that you are able to identify people who understand the environment are then allowed to police the areas. And that makes a lot of sense. You talk about security, which is also very critical for this administration. Security is very critical. And I think we have the capacity, the competence, and the character to address the scourge of security in Nigeria. Part of the problem is compromise. And I say that advisedly. A lot of funds deployed for security purposes are found positions in wrong hands. A lot of funds are deployed for security. Humongous amount. The question you have to interrogate is whether these funds are effectively utilized. And whether there's a political will, and that is critical. If you want to deal with any problem, whether corruption or security, you must have the political will to go the whole hog, to deal with the scourge. You can see that during the elections, you never had of incidents of so much, upsurge, as if I've gone to sleep. There are certain, vested interests that are escalating this. So what the system needs to do is to identify these vested interest elements and deal with them according to law. You understand what I'm saying? Nigerian army is one of the best in sub-Saharan Africa in terms of, intelligence, capacity, competence, and then professionalism. The question you want to ask is whether they are sufficiently motivated or empowered
to perform the task
assigned to them. And that is the narrative that must change. The Buhari administration may have done its best, but its best, in my view, is not the best for what has played out. Because the Chibok girls are still there in captivity, and a lot of security challenges across. In some parts of the country, you cannot even come out on a particular day to do your business. So we have security challenges everywhere, the north, the south, everywhere. And then when government fails to deliver with respect to security and welfare of the people, which is the primary purpose of government, the government has failed.
Don't you have fear? As somebody who was one of those who fought for democracy and made some significant sacrifices, aren't you afraid that if the security forces or the forces of enforcement of security are decentralized, already even without them being decentralized, we are complaining about how the central authorities are using them, sometimes for political, personal, selfish motivation. Aren't you afraid that if governors, get hold of this kind of powers, they may use them to the detriment of society? I mean, because that had been one of the arguments that had been made by those who opposed, allowing them, because many of these people are politicians, allowing them access to this kind of powers.
You cannot, because of fear of abuse, preclude yourself from doing what is right. Yes, there's no system that is not open to abuse. You might have isolated cases of people trying to abuse their powers. But that's why we also have the law. We have the judiciary in this case. A lot of these abuses go unchallenged because people fail to really fight for their rights. You understand what I'm saying? And I think it will be quite unfair to say Nigerians are one of the most enlightened people across board. So if you are talking of abuse, don't you have abuses even at the federal level? Misuse of powers, executive lawlessness, both at the federal and state level. This is like, but that's not sufficient excuse to say we should not do property. We say we made a choice that we are practicing federalism. That's our choice, a federalist constitution. Then we should live up to that belief. We should walk the talk. For God's sake, we should walk the talk. Is it that we want to practice federalism or unity system of government? Or want to go back to parliamentary system of government? It's our choice. So once you have made a choice, you should live with the choice. So we cannot say in one breath that we are practicing federalism, and then when in actual fact, what we are practicing is a unity system of government. When you have an over-bloated federal government at the expense of the federating units. For instance, you have a governor of a state who is described as the chief law officer of the state, who has no control over the commissioner of police. The commissioner of police is answerable to the inspector general of police in Abuja. And so if he has genuine security concern, if the commissioner of police does not agree with it, it's not carried out. So I think we should, not only on law enforcement, the other areas, critical areas, that when you decentralize, it has a lot of advantages. And then the center can handle essential services like defense and some other issues like that, foreign exchange, and so issues like that can be handled by the federal government. But if you want to practice true federalism, true fiscal federalism, then we should follow the templates established by those who practice it currently successfully.
What you have said so far will give me the impression, and possibly a lot of the viewers, the impression that you have quite a lot of confidence and trust in the judicial system, because apart from the fact that you are a lawyer, which means that you are a member, either directly or indirectly, of that system, you've seen its operations at close quarters. You seem to have quite a great deal of trust and belief in the system. But there are those who have said, well, down the years, especially more recently, there has been contention over, the absolute trust and integrity, which is why some of the things you referred to earlier on as people going to the court, but at the same time trying to intimidate or blackmail and so on, because they are not 100% sure that justice will be done and be seen to be done. There have been quite a number of controversial judgments at various levels of the courts, even courts of coordinate jurisdiction giving divergent judgments on same case and so on, allowing legal practitioners or litigants to window shop for judgments, as all that is still going on. So I want you to put your trust and belief in the system on one side and look at the fact that the judiciary is not immune from the society, and that therefore all the ills that the people who are going to the judiciary to report are also ills that plague the judiciary itself.
Thank you very much. There are a lot of reasons why I should have faith and further reinvest faith in the judiciary. Apart from having practiced the law for close to 35 years, I'm also a member of the INEC as a senior advocate of Nigeria. And I also know as a matter of fact that if you withdraw faith from the judiciary, that's a sure recipe for anarchy. The judiciary sustains, oils the system. In fact, another name for this our democracy is rule of law. If you say you are practicing democracy and you don't have respect for the rule of law, you are deceiving yourself. And who is the custodian of the rule of law? The judiciary. And if you want to be very factual, if you look at across all the hierarchy of our courts, from the magistrate court to the high court to the court of appeal to the Supreme Court, you see that about 80 or 90% of our judges are men and women of sterling integrity. The few, in any system, you cannot but see few bad eggs. For instance, Chinese is generally adjudged as the best or one of in Africa because of your professionalism. But that does not mean you don't have some fiancé that you need to look into, to fish out, take out of the system in order not to compromise your integrity. It's the same thing with the judiciary. For instance, if you look at the Supreme Court, look at the Chief Justice of the Federation, Honorable Justice Oluka Ariwola. If you studied his career trajectory, and most members of the panel of justices of the Supreme Court that I know, but there are people who cannot be compromised. Same goes for the Court of Appeal. I'm not saying you don't have few elements. And then we have an inbuilt self-regulatory mechanism for dealing with such. Only the judiciary has agency, for instance, to deal with any members. The NBA has its own disciplinary committee to deal with the lawyers who run foul of the law. And they are sitting every time, handling down decisions. What people need to activate is, the need to, when you see a judicial officer or a lawyer running foul of the law, you take adequate measures to ensure that he or she is brought to book. But I think it is dangerous for us to begin to label our judiciary as corrupt because of the activities of very few. This general label is a disservice not only to the judiciary as an institution, it's also a disservice to the collective well-being of the society. Because what you are now saying is that, don't let us take our dispute through the judicial process. Let us resort to kangaroo or some kinds of, jungle justice in order to deal with our problem. And once a society descends to that level, that's a sure way to anarchy. You and I is not safe. You are not safe under such an environment. We cannot even having this kind of discussion. If you have if anarchy looms in the society, and that's why we should always guide, and that's why I salute what the press and the media is doing, because all of us have a duty to deepen our democracy process. We have a duty to advocate for a vibrant, courageous, fearless, result-driven judiciary. So the advocacy should be so it's not just because of you and I, because we'll go ultimately. But these institutions remain. So we should not do anything to compromise the integrity of these institutions. If we have members who are doing some kind of activities that are inimical to the progress of society, it is the duty of you and I to expose such members. And there are mechanisms. Because someone is a judge does not mean he's immune from disciplinary actions. No matter how big you are, the law is bigger. That's the glitch. So, and then what we should encourage is advocacy for transparency and accountability in public office. We should also advocate for law and order approach. There should be consequences for criminal infractions. In this country, you've seen judges being tried for one criminal infraction or the other. There's nobody that has not been taken through the legal process, no matter how powerful you are. That is the kind of thing we should encourage. We should not just label all the judiciary in general terms as corrupt when we don't have evidence.
Senior Advocate of Nigeria, Shittu, thank you so much.
It's a pleasure. It's a pleasure, sir. Thank you so much. Thank you. Thank you.
That's our program today. We would, of course, like to hear from you on the conversation. Our social media handles are right there on your screen. You can also listen or watch this and previous episodes of the program via our podcast or YouTube pages. Please visit our website, channelstv.com, to get started. I'm Ladi Akeredoluale. Goodbye.